It has quite a number of new laws that were passed and that pertain to us, but I'm only going to be covering the ones that are most important to us. So common interest development refers to condominiums and townhomes. This particular new law requires the owner of a condominium or townhouse in a common interest development to annually provide the association with specified written information for the purpose of receiving notices from the association. So this particular law requires an owner each year to provide written notice to the association with all of the following information. One, the address or addresses to which notices from the associations are to be delivered. So if you are a condominium owner or townhome owner, you have to let your association know where you prefer to receive notices on an annual basis. So if you're managing a condominium complex or townhome complex as a property manager, you need to know this new law because you are going to require each resident of the units that you manage to let you know where to send legal notices. In addition, they also need to tell you an alternate or secondary address to which notices from the association are to be delivered. So not only must they tell you the primary address where they want to send notices, in addition, they must also give you a secondary address in case the association needs to know that. Third, the name and address of an owner's legal representative, if any, including any person with power of attorney or other person who can be contacted in the event of the owner's extended absence from the separate interest. Now, a perfect example will be when you have a property owner who lives in China, but he owns an investment property in California. And this investment property happens to be a condominium or townhouse. So if you are the attorney in fact on a power of attorney, you are to provide the required information as stated on behalf of your principal, who is the owner of the property, to the association. And that information will include the name and address of the attorney in fact. Okay. Number 4, whether the separate interest is owner occupied, rented out, if the parcel is developed but vacant, or if the parcel is undeveloped land. So that's information. So you are supposed to let the association know if the unit is rented out. So I guess, if you have a complex where they don't allow rental, and if you tell them through this disclosure that the unit is rented out, that's one way they're gonna find out that you're in violation of the CC&R. Okay. Number 2, requires an association to solicit annual notices of each owner, and at least 30 days prior to making certain required disclosures. Enter the data into its books and records. So association has its own part as well. There's actually a requirement. It says required, so it's mandatory. So the association has to write letters, send notices to every owner to tell them to make such disclosures. And upon receipt of such disclosures, the association shall enter the information into their books and records. Number 3, the new law specifies that if an owner fails to provide the information specified in the above provision, the property address shall be deemed to be the mailing address to which notices are to be delivered. So in other words, if you have a property owner who lives in China, and the property is being rented out. And each year, the association will send you a notice to require you to provide the address to which legal notices are to be delivered. And if you do not respond, then the association can send all notices to the property address and use the property address as the mailing address. Now, whether or not your tenant forwards the mail to you, and if you fail to receive legal notices because you never provide an address to which you want legal notices to be served, and instead the association served the legal notices at the property address and the tenant fails to forward it to you, the notice is still valid. Okay. So now, why is it important that notices are being sent to the property address? Well, so one thing for sure, sometimes the association needs to communicate with you because your tenant has committed certain violations of the CC&R. And in order for the association to impose fines on you or to take any kind of legal action on you, the association would need to give you an opportunity to correct the violation. So typically, they will hold board meetings and invite you to the board meeting to explain your action or lack of action that caused the violation. So that's one reason why you want to make sure that if there are any legal notices, they have to be sent to the address that you want to send to, because if you send to the property address, there's no guarantee the tenant will forward it to you. The tenant may not forward it to you, and you would have missed the important legal notices, and you would have forfeited certain legal rights and they impose fines on you. Okay. All right, next. I'm sure you guys are familiar with this next one. It says disclosures, death of occupant, rule clarified. It says the existing law concerning disclosure, death of an occupant is clarified to say that death of an occupant or the manner of death occurring more than 3 years prior to an offer to purchase is not a material fact which requires disclosure. All right, here's the scenario. So this is the new law, and this one actually has been effective since September 25th, 2016. It says existing law concerning disclosure of death of an occupant is clarified to say that the death of an occupant or the manner of death occurring more than 3 years prior to any offer to purchase is not a material fact which requires disclosure. Now, interesting, this one talks about purchase. Why doesn't this one talk about leases? I don't know why, but the new law actually talks about purchase only, an offer to purchase. Now, let's say if you have a tenant, an occupant, a previous occupant on the property. Could be a tenant or a previous owner, it could be anybody, or just a relative of the previous owner, just anybody that had died on the premises more than 3 years ago. The law says you're not required to disclose because it is not a material fact. Any death that occurred more than 3 years ago, regardless of how the death occurred, it's not a material fact, which means that it requires no disclosure. However, there is no clarification on the next issue, which is, while it is the law that the owner and the listing agent are not required to disclose any death that had occurred more than 3 years ago, must the listing agent disclose any death that had occurred more than 3 years ago, if asked by the buyer. I'm sure you guys studied this in my property management. And the answer is, even if the law says it is not mandatory for you to make disclosure of any debt that has occurred more than 3 years ago on the property that is being listed for sale. However, if you are asked point blank and specifically by the listing agent, by the selling agent, who is the buyer's agent, or the buyer, an agent must not hide the truth if asked that question, but an agent is not required to volunteer any information on the debt of an occupant of a property if that occurred more than 3 years ago. Okay, just make sure you understand the law, and if you're asked, you have to just be honest. Okay, you're supposed to be honest and just tell people the truth. If they don't ask, don't tell, because it is not a material fact. Now, they say it's not a material fact. Now, what if you're asked, was there a debt on the property before? Are you required to say, yes, there was, and it occurred 4 years ago? They say it's not a material fact. If you're asked a question, even if something is not a material fact, and if you don't tell the truth, could you be sued? Normally, they say if you lie about something, and if that fact is a material fact to the buyer, you could be sued. But if here they say it's not a material fact, if it's not a material fact, you're asked about it, instead of saying, yeah, the debt occurred more than 4 years ago, you say to the buyer, no, there was no debt more than 4 years ago, when in fact you knew that there was a debt, right? Could you be sued for fraud? Or should you be sued for fraud? What should you do in this case? Now, certainly, you may engage in a discussion with your seller. Seller say, hey, you know what? You know the California law says if the debt occurred more than 3 years ago, you don't have to tell the other side, right? And your seller say, don't ever tell the other side, even if they ask you if there was a debt more than 3 years ago. What are you going to say to your seller? The truth? If you say the truth, you can never go wrong. But how will telling the truth in this case affect buyer's impression of the value of the property? It may or may not. I mean, debt is a natural occurrence. If you say there was a debt, right? Let's say you tell the truth. Okay, there was a debt, right? Naturally, the next question is going to be, well, how did the guy die? What was the cause of the death, right? All right, that becomes a more critical question. If you are asked about a debt that occurred more than 3 years ago, and you're asked about the cause of the death. Now, if previously your seller has asked you not to disclose any information about prior debt because it was more than 3 years ago, what are you supposed to tell your seller? All right, I will not say anything. But how can you not say anything if you ask a question point blank? Was there a debt more than 3 years ago? You have to say something. Remember, you are not only bound by the laws, you're bound by the code of ethics too. You know, even though the law simply say you don't have to volunteer the information, I don't think the law says, you know, if they change the law and says that, hey, you know what, agents are not required to respond to any question about any debt that occurred of the property if the agent knew that the debt occurred more than 3 years ago. If the law says that, then you tell the guy, the law says I don't have to respond to that. But naturally, if you tell the guy I don't have to respond to that, they're going to suspect that there was a debt more than 3 years ago, right? Because if there was no death more than 3 years ago, you would simply just say there wasn't any death more than 3 years ago. Now, another place where death is mentioned is on the SPQ, the Seller Property Questionnaire. If you remember the SPQ, there was a question that asking about death, right? Was there any death within the last 3 years? There wasn't any question about was there a death more than 3 years ago, right? So you will not be, unless they ask you point blank, that SPQ answer basically takes care of the question of whether there was a death less than 3 years ago. And then because it wasn't on the SPQ, and if you are not asked, you won't even ever have to be engaged in a conversation with the selling agent about whether there was a death more than 3 years ago. Now, if you are a selling agent, right, if you are never asked by your buyer about whether or not there was a death more than 3 years ago, do you want to ask the listing agent, or should you just avoid the conversation altogether? You know, if I were you, I'll avoid the conversation altogether. Frankly, I think if the death has occurred that long ago, it's probably not a material fact anyway. Plus, now the law makes it explicit. They tell you as a matter of law, it is not a material fact, okay? By law, death that has occurred more than 3 years ago is not a material fact. Therefore, if you do not disclose it, you can never get into trouble unless you are asked point blank and you misrepresent the truth. If you are asked point blank, I don't think you have a choice. If you are asked point blank, was there a death? Some buyer may be so particular about death regardless of when it occurred, right? I wouldn't want to get into trouble. You know, I don't want any issue if I'm asked point blank, was there a death? Now, what if you're prohibited by the seller? Now you are torn. Seller say, I don't want you to say anything about death. All right, then I ask the seller, what do you expect me to say? Just ignore their question? Or can I say my seller said not to tell you anything about death on the property? You know what, the minute you say that, they're going to suspect there was death on the property, right? Because, you know,
with information, we can investigate later.
No, you can't say no information. You do have the information. You just said that my seller specifically instruct me not to disclose any information about death on the property. Can you say that if your seller insists on your... No, I mean, if your seller insists on your not disclosing any information about death on the property if it occurred more than 3 years ago, if you're asked a question about death on the property at any time, here would be my response though. Now, if my seller specifically said, I'm telling you, don't disclose any information about death on the property more than 3 years ago. Okay? All right. So what am I supposed to tell them if I'm asked? You tell them, I tell you so. Okay, fine. Seller told me not to tell you, so seller said, I can't disclose any information about that that occurred more than 3 years ago. You can say that, right? That's a response if you're asked by a buyer, right? Because your seller said, don't say anything about that occurred more than 3 years ago. You have to abide by your seller's instruction. At the same time, you have to abide by the code of ethics about no misrepresentation. You are not misrepresenting anything. If you simply convey what instruction you were given by the seller to the buyer, that's not telling lie. That's basically telling the truth. But on the other hand, if you say, I have no information about death on the property more than 3 years ago, that's a lie. You can get into trouble. You see the distinction? One say, seller say not to say anything. The other one say, I got no information, when you in fact have information, right? Okay. Now, they had to clarify the law recently because previously the law wasn't explicit about saying that death on the property that is more than 3 years ago is not a material fact. Previously, the law says you cannot be sued if you fail to disclose any death more than 3 years ago. Now they make it more explicit. Not only could you not be sued, the reason why you could not be sued is because death that is more than 3 years ago is not a material fact. That's why you could not be sued. So they make it more explicit. But I think the end result is the same. Could you see any possible distinction between having a law that says you could not be sued if you don't disclose any death that is older than 3 years versus one that says death that is greater than 3 years is not a material fact? I think there may be some distinction. In the new law, it's clearer why you could not be sued. And the reason why you could not be sued because it is not a material fact. It is absolutely clear. Whereas previously, nobody knows why the law says you could not be sued. We can kind of imply why you could not be sued. The reason you could not be sued previously for not disclosing death that is greater than 3 years is because it's not a material fact. But before, it wasn't explicit. Now it's very explicit. That is not a material fact. Okay. All right. So much about death that is greater than 3 years. Now, you know we learned about HIV, right? Now, that law has remained the same, though. The law has not changed. It says here, if you look at the screen, it says additionally, this law clarifies that no disclosure is required where an occupant of the property was living with human immunodeficiency virus, HIV, or died from AIDS-related complications. Now, here's the tricky part. It says you're not required to disclose about anybody who's had AIDS that had lived on the property. It says you're not required to disclose. That is to say you will not get into trouble if you disclose. No, it doesn't. That is to say you will get into trouble if you disclose that the previous occupant, there was previous occupant that had HIV. It doesn't say either. So, should you say or should you just keep quiet as a matter of risk management? Should you disclose? Think about it. Why do they have such a law? If somebody had HIV on the property, could it be a material fact? It doesn't say here, if you look at the new law, it doesn't say that the information about HIV is not a material fact. Think about it. If you're a buyer, you're buying a property, and the previous occupant had HIV, would that somehow influence your decision to buy this property? Yes or no? It could, right? Why? Because you're afraid of contracting AIDS if you live there? But how can you contract AIDS if you don't have any exchange of bodily fluids? Probably not. Have you ever heard people that contracted AIDS after they bought a house that had an HIV occupant? I don't think so. So why is it that you think it's a material fact, the fact that the previous occupant had HIV? Are you afraid that if you buy this property, in the future you sell it? But in the future you sell it, you don't have to disclose. There's no disclosure is required. So why is it that it's a material fact to a buyer? I don't think it's a material fact to a buyer, correct? Now, certainly your seller will be very upset at you if you disclose information about HIV to the buyer. So should you disclose or not disclose? It's a no-brainer. you don't disclose. Okay? Don't disclose. It says no disclosure is required, right? So the law says disclosure not required, so don't disclose. Okay? All right, next one. This next one is about disclosures, liability, protections of environmental hazards booklet extended to landlords, effective January 1st, 2017. Liability protections for delivery of the residential environmental hazards booklet extended to include leases of more than 1 year. Now think about the environmental hazards that exist on a residential property. Well, if the property was built pre-1978, then, there may be risk that the paint that was used contained lead. So lead is an environmental hazard that might exist on a residential property. The other hazards like formaldehyde, where would you find formaldehyde? I think you find formaldehyde on some furniture. Formaldehyde is used for, somebody told me that it's makes it easier for you to wipe spillage. I don't know, but formaldehyde is potential environmental hazard in a residential property. What other environmental hazard might you have? Sometimes you might have popcorn ceiling. What kind of hazard might you find in a popcorn ceiling? Asbestos, right? Potentially you got asbestos. So asbestos is also a potential environmental hazard. Okay, so asbestos, lead, formaldehyde. Of course, we always have radon. Radon is also an environmental hazard. Now, all of these hazards, a mold is also considered an environmental hazard. Sorry, I forgot about mold. Hey, this is a great pamphlet to use to minimize your mold liability exposure. One of the heavily litigated environmental hazard area is mold. So if you can shield yourself from mold liability simply by handing a booklet to a buyer, why wouldn't you want that? This law clarifies that the liability protections for delivery of the residential environmental hazards booklet extend to leases of more than 1 year's duration. So in other words, previously it already exists. If you use a booklet, hand it to your buyer, it sort of gives you that extra protection for liability. So if at all possible, always provide that booklet. And if you want to know where you can get a free copy of the booklet, you go to the agent's folder. Inside the agent's folder, we have a subfolder known as Disclosure Handbook Package or something like that. And inside that folder, I think this booklet is available in PDF. Okay, so it is always a good idea to use this booklet to give yourself extra protection against lawsuits for environmental. Particularly, who is that? Who's making noise at me? Hey, Carlos, it's you again. Okay. All right. Let me go back to this one here. So it says that the law classifies that the liability protections for delivery of the residential environmental hazards booklet extend to leases of more than 1 year's duration. So if you sign leases of more than 1 year in duration, it's a good idea to provide this booklet to the prospective tenant. Under Civil Code 2079.7, when a seller or broker elects to deliver this booklet, the information is deemed legally adequate to inform the transferee regarding common environmental hazards, such as asbestos, formaldehyde, hazardous waste, household hazardous waste, lead, mold, and radon, and additional general information on these issues is not required unless the broker or seller has actual knowledge. So in other words, if you do your visual inspection, you look under the kitchen sink and you see mold, can you say, well, I don't want to tell the buyer this. I'm just going to hand the booklet to the buyer and I don't have to disclose. Can you do that? Or do you still have to disclose? You still have to disclose. So as you can see, it does not protect you against fraud, but it might protect you against negligence. So there's a distinction between fraud and negligence. Now let's say, for example, you do your visual inspection, correct? And you somehow neglected to inspect the area under the kitchen sink. And the buyer brings a lawsuit against you, right? And the buyer said, all right, you were negligent in doing your visual inspection. And the buyer brings a lawsuit against you. You say, no, you can't sue me because I gave you this booklet. Does this booklet shield you from liability if you missed the area under the kitchen sink and there was mold under the kitchen sink? I don't think so. I think you should still be liable. So I guess it doesn't really give you a lot of protection. I think the only possible protection is if the lawsuit is based on your negligence in failing to advise the buyer to do a mold inspection. Now, if the lawsuit is, let's say, for example, you represent a buyer, and somehow after the escrow closed, mold began to grow. However, mold was not visible. In other words, mold could not be seen, but mold was hidden behind the wall. And the buyer said, well, you know, as a professional, you should have advised me to do a mold inspection report, because had I done a mold inspection report, they would have collected samples from the air. And if they had collected samples from the air, they would have discovered there was mold in the property that was not visible but could be detected in the air. And because of that, you were negligent. Therefore, you're liable to me for not advising me to get a mold report. Now, if you had given this booklet to your buyer, could you shield yourself from liability in that situation? Yes, you can. Because you were not negligent in doing your visual inspection. Even though mold was in the air, it was not visible. Of course, unless you can smell it. If you couldn't smell it, you couldn't see it, and there was mold in the unit, and you never advised the buyer to get a mold inspection report done, and you have given this booklet to the buyer, you would be safe, wouldn't you? Right? So I think it's useful for that limited situation only. It doesn't shield you from liability on the other two situations. One, for failing to do your visual inspection properly. The other, for actual fraud. In other words, you knew there was mold and you didn't tell. So for those two situations, there's no protection. For the last one, yes, there is protection. Okay, so very useful booklet to use though, nonetheless though. You can actually save yourself some legal trouble. Now, it's not always that when the buyer sues you that the buyer is going to win, but still legal trouble. And we don't want legal trouble, right? If at all we want to minimize legal trouble, right? Even if you're going to win, but there's still legal trouble. So try to use this booklet as much as you can, okay? Now, they also say that this booklet can be applied to commercial properties as well. Now, let's say, for example, you are involved in a warehouse transaction, and there was mold on the property, but they are not visible. Remember, for commercial transaction, there's no legal requirement that you do your agent visual inspection for commercial. The agent visual inspection disclosure is only mandatory for residential 1 to 4 unit, correct? Now, let's say, for example, you are a selling agent representing a buyer for the purchase of a 5-unit apartment complex. Are you required to do an agent visual inspection disclosure or not? 5-unit apartment complex. No, right? Agent visual inspection disclosure is only required for residential 1 to 4. It's actually 1 to 4 dwelling units. A 5-unit apartment complex, it's a 5 dwelling unit residential property, and therefore agent visual inspection disclosure is not required. For a 5-unit apartment complex, is the seller required to provide a transfer disclosure statement? No. Transfer disclosure statement is only required if it's a 1 to 4 dwelling units. Remember that, right? So if you represent a buyer on a purchase of a 5-unit apartment complex, and since the law does not require yet that you do an agent visual inspection disclosure, you perform no visual inspection, right? And during your brief walkthrough, you did not discover certain areas where mold was actually growing. Could you be sued for negligence for not having seen the mold? The answer would be no, because you're not required to do an agent visual inspection disclosure, correct? Now, then the next question. The buyer say, well, you're the professional. You should have advised me to get a mold inspection report done for a 5-unit apartment complex. That is a standard of care issue. Would a competent agent have advised the buyer to get a mold inspection report done, just as a due diligence for the purchase of the property? It becomes a standard of care issue, and some attorneys, they don't care. They'll just bring in the agent. They're going to say that you as the selling agent should have advised the buyer to do a mold inspection report. This property was built in 1964. You know, such an old building, you should have suspected that perhaps there might be mold growing on the property that's not visible to the eyeballs, right? And if you don't do that, a lawsuit could be filed. And if you did not use that booklet, you lost out on that automatic defense, right? And then you have to hire a lawyer just to fight off this nuisance lawsuit. But on the other hand, if you have given this booklet to the buyer, right, that is like an automatic shield from this type of lawsuit, because then, you know, your attorney will be able to tell the other side's attorney and say, hey, look, this is what California law says, okay? It applies to commercial property too, no? Actually, it really doesn't say it applies to commercial property. It says liability protections for delivery of residential environmental hazardous booklet extended to leases of more than 1 year, but it doesn't restrict itself to just residential now. If you look carefully, it does give the extra protection even for commercial, no? Read this. It says the protection now includes leases more than 1 year, not just necessarily residential. And I said delivery of this booklet is optional. See, the delivery is optional, but even if it's optional, do you want to make it mandatory for yourself? Absolutely, don't you? That's right. This booklet is intended for consumers and is described as a consumer information booklet. Okay, nonetheless, the new law will make its protection applicable to real property, which includes commercial and vacant land properties, but not, interesting, but not multi-unit residential rentals of 5 units or more. What does that mean? Nonetheless, the new law will make its protections applicable to real property, which includes all commercial and vacant land, but not multi-unit residential rental. That's a bit confusing, isn't it? If you look into the definition of CoStar, a 5-unit residential rental is by definition a commercial property. Okay. Now I don't care what that they said you don't get that protection, but I still make it mandatory. If I'm in a transaction like this, it's mandatory for me. Okay. All right. That concludes today's training on the new law. Next week we'll have more training on the new law on other issues. Okay. And thank you all for participating, and thank you for attending.